and how you acted here in court and once you got to jail that day that's just a very immature way
Yes, ma'am.
of handling things. And it also, of course, gives me a lot of concern on whether or not I should give you a probation. So I'm glad to hear that. Anything, Mr. Smith, before I sentence?
Judge.
All right, then, Mr. Rayleigh, I'm going to give you this opportunity today. I'm going to find that you previously entered your plea of guilty freely and voluntarily. And this is cause number 25 DCCR 1482. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation. About, remind me, Brandon Louie? It was Mr. Smith? Okay. Okay. See, this is Mr. Nichols on Corbin Rayleigh. Good morning.
Good morning.
You're Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh was previously in court in cause number 25 DCCR 1482, entered a plea of guilty to the state jail felony offense of engaging in organized criminal activity. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. Yes, sir.
Any additions or corrections?
No, Your Honor. Not from this time. Comments?
Go ahead.
Just that I want to tell the court that this is a completely different young man than I saw in court previously and at my office or over the phone. He's polite. He understands the proceedings that are going on. He understands that I think the comments that he made to the probation department were before or immediately after going to jail. He understands now that what he did is a felony. He accepts responsibility for it. In talking with him this morning, he's like I said, he's a completely changed individual. I think he's going to do well on probation if he can keep this up.
That's good to hear, Mr. Rayleigh. You're very young, and the episode, you're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the JCDI program, which is an outpatient treatment program to make sure you are clean and have all the tools to stay clean, as well as any type of recommended treatment for any mental health issues that might be going on as well. Okay, so you're required to do those things, whether you feel like you need them or not. It's all just so that I want you to be successful in this to be a turning point. You change your life. Okay. This is a great opportunity. You're young. You don't have a felony conviction on your record. And if you successfully complete this probation, at the end, the case is dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you don't follow through with treatment, you test positive for drugs, you don't go to appointments, whatever it is, you're going to be back in here. You could be convicted of the offense, so you'd be a convicted felon and go to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get out today. Probation will talk to you before you leave the courtroom, but the first thing you do is make sure you follow their instructions, go straight to probation, get everything started and do well.
Yes, ma'am.
Okay. Good luck to you. Thank you, Mr. Rojas. Ms. Holmes, you've got Frederick, oh wait, let's do Martin Fonseca Cardenas.
Yes.
Good morning. You are Eric Gibson.
Yes, ma'am.
And Mr. Gibson has 4 cases set for trial to begin with jury selection next Monday. And what is the announcement?
Your Honor, we're ready, except we did get new discovery on Friday. I got over 80 pages of medical records, and I'm definitely not through those yet. I mean, I can be by the end of the week, or I will be if I have to be.
Okay.
But
Mr. Smith,
State's ready.
are those things that you just received, or why was
We had-
that so late?
We had issued a subpoena ducis tecum to the hospital. It's name records or whatever, and for whatever reason, they weren't delivered the last time we sent subpoenas out. They were delivered this time.
All right. Well, since you got them, I mean, it was over a week and a half out. So I'm going to number the case.
Okay.
Has there been any change as far as negotiations or anything like that I need to take into consideration?
Okay.
All right. So I'll number the cases this afternoon. I mean, today after docket, you
Okay.
guys will know the trial order this afternoon.
okay,
All
thank
right.
you.
We'll see you next week.
Well, yes, we'll get there. They still get those to these people.
Good morning, sir. Are you Tasia Mack?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
We will.
No, this has just been going on a long time, so I've got lots of pages to scroll through to get all the way back to the indictment. There it is. Mr. Mack, in cause number 24, DCCR 1046, you're charged with the state jail felony offense of criminally negligent homicide from March 10th of 2024. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then, let's see, 85, in cause number 26, DCCR 0085. You're charged with a third-degree felony offense of bail jumping and failure to appear from December 15th of 2025. And how do you plead to that charge? And again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In both of those cases, I have here on the tablet and some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Shipley?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Mack is not competent?
There is no evidence.
All right, Mr. Mack, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 24, DCCR 1046, find sufficient evidence to find you guilty, and at this time find you guilty of criminally negligent homicide. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0085, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of bail jumping and failure to appear. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. And I'm going to sign a dismissal as part of this agreement, and cause number 26, DCCR 0086. If you'll please print 1046 for me. I sent it to you. Apparently it didn't print. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you did waive your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Jipley. All right. Good luck to you, sir. Thank you, ma'am.
Thank you. Yeah. See you on the other side.
Yes, ma'am.
Ma'am. Mhm. Yeah, yeah. Uh-huh. I thought we already, it's set for trial. For next week, I don't know why they're trying to do it anyway.
Anyway.
Ms. Perazo on Traylon Hill. Yeah, it's free trial, except for trial next week. Morning.
I just realized 2 different shoes.
Do you?
Yeah, they look
That's
the same
awesome.
in the-
That's funny.
Now are they both the right or the left or the different?
They're right in it up, but don't know.
I've done that.
know. Don't
Two
know.
lefts.
Yeah.
They're both black.
If
That's
you wouldn't have
good.
pointed it out, nobody would know.
Traylon Hill.
Okay. I'm from the other side.
Okay, I'll call it as soon as he gets
Okay.
back over here. Mr. Radford on Christopher Bushnell. Do we have him over here?
Yeah, Bush now?
Good morning. Good morning, you're Christopher Bushnell. And Mr. Bushnell is here. We've got cause numbers 25 DCCR 0112 and 0113, where there are motions to revoke Mr. Bushnell's probations in each of those cases. And then we've got 3 new indictments. We've got 26 DCCR 1222. Mr. Bushnell's charged with murder. 1223 charged with aggravated assault with a deadly weapon, and 1224 also charged with aggravated assault with a deadly weapon. And Mr. Radford, what is the announcement?
Judge, I have visited with Mr. Bushnell, about, his version of the event. I have just recently received an offer from Mr. Coleman. I'm waiting on the media.
Okay, so is you're taking this one though, aren't you? Or is this gonna be?
No, Mr. Coleman's already worked it up, met with the family and per some instructions above my head. He's also gonna be involved. I told him, of course, I would assist. He's aware of the court's concerns about his going back and forth, so I will obviously stand in for whatever is needed. in assisting with it.
All right, and I'll probably talk about that as well with them, because it's just gonna be, it's too hard to have him over there and trying to come back over here, especially on cases that need to get taken care of, with a lot of information. So I'm gonna do a normal reset, and to give you some time to get all that media and then go over it with Mr. Bushnell, and we'll see where we get at the next court date.
Yes, ma'am.
All right, thank you. You can go back with the bailiff.
May I be excused?
Yes, sir.
I'll express that concerns that if you want to go back upstairs.
Okay, thank you.
We have Mr. Gilman on, Judge.
Mr. Hill, come up, please. This is Mr. Nichols' case, is he?
Thank you for having me today. I want.
Hold on, don't talk yet. All right, are you Traylon Hill?
Yes, ma'am.
And this is cause numbers 24 DCCR 1500, 1614, 1615, and 0436. Mr. Hill's cases are set for trial with jury selection to begin next week. And what is the announcement?
We're ready for trial.
State's ready.
All right, then
I
I'm
didn't wanna
going
go
to,
trial with it.
what?
I didn't want to go to trial with it.
Do you want to take a plea agreement?
I want to file some motion before I go to.
You don't get to file motions, Mr. Hill. Your attorney's taking care of all that. You don't get to, don't talk over me, Mr. Hill. We've been through this too many times. Your case is set for.
Talk to, I don't want to go to trial, because I don't have any evidence on my case. I want to
Okay.
get a release of discovery, dismissed because of delay, dismissed because it's still a complaint.
That's all denied. Mr. Hill, go back with the bailiff. Your case will be going to trial probably next week.
That doesn't make any sense.
Go back with the bailiff.
Why you-
Always like she does, Mr.
Oh, damn. Why would you push me like that?
Parker, you got Malcolm Williams.
Yes, ma'am.
I didn't mix. No. Interview for continuing probation, so I just put continuing probation.
Say it again, I'm sorry.
I didn't know what to put on the motion to vote because he's going to continue
Oh,
probation.
okay.
Part of his plea deal has to get an ID. He's a transient. That's been his issues.
You can't be treated at this middle top without
An ID.
a valid idea of something.
Oh, excuse me.
Good morning. Are you Malcolm Williams Jr.?
Yes, ma'am.
Give me just a second. My screen's now locked up. Will your client waive the formal reading of the motion
He will.
and the indictment?
Yes, sir.
If I can get to it, let's see here. Okay, here we go. Mr. Williams, in cause number 26 DCCR 1254, you're charged with the third-degree felony offense of failure to comply with sex offender registration requirements from June 2nd of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they've charged you with?
yes, ma'am.
In that case, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So that looks like the agreement that you've reached is for a 4-year term in prison, but that would be probated. You'd be on probation for 4 years. You'd be required to follow all of the rules and conditions of probation, including getting an ID within 90 days of sentencing. That's the most important thing because you have to have your ID so that you can register. You understand that?
Yes, ma'am. I got a question. It's not, I'm just trying to see how long, like, would it usually be to get an ID? Like, let's say.
You can get one they can give you
Yeah,
a
you
temporary
can-
one until, when you go there, they'll give it to you.
You'll get a piece of paper that day and then they'll mail you the actual plastic copy later. So as soon as you go in, and you probably will need
Cause
either.
I'm playing, let's say, because might be, if whatever I get out, I might be walking this day, and I'm planning to go tomorrow, the next day.
Right,
That'd be
so
fine.
you're gonna have plenty of time and probation will help you. So when you get out of custody and you start your probation, you're gonna go, the first thing you're gonna do is go to the probation office.
Yes, ma'am.
You can ask them all those questions and they will help you with everything. Okay, because you're probably gonna need some other information. You're gonna need to get a birth certificate or something else too before you go get that. So they'll help you get everything you need. Just ask for that help. That's gonna be the main thing, is that you don't try to go do it on your own and then get frustrated because it doesn't work and then not do it. Okay, probation is gonna be there to help you get that taken care of. You understand?
And then I still gotta go inmate tomorrow.
Yes, for sure. Yeah, that'll be part of your probation as well, so that you get any help you need so you can be successful, get on the right path and take care of everything.
Yes.
Okay. And you're a US citizen, correct?
Yes, ma'am.
Okay. State tender's number 1 in that
No
case.
objection?
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
Is there, I don't typically waive a pre-sentence report on a third, but because he's already on and we're going to continue him, is there any reason not to go ahead and waive that so we can get him started?
I don't see one.
Any other additional information?
No, we have a lot of information already.
Okay, so in that case, which is 26-1254, I'm going to find that you just entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of failure to comply with sex offender registration requirements. Sentence you in accordance with that agreement to a term of 4 years in prison, but I'm going to probate that, so you'll be on probation for 4 years. There's not going to be a new fine in that case, but you are required to follow all of the rules and conditions of probation. Again, including getting that ID taken care of, making sure you follow through with any mental health care, community service, everything else you're supposed to do while you're on probation, okay?
Would it be the same,
Yes, it will.
The same,
community service,
you're probably going to have a little bit more because of the new case, but probation will explain all that to you as well, okay? Now, the next case we have is cause number 23-41505. Let me find it. And it's my understanding in that case that the recommendation, you're on probation, is just to continue on probation. Is that correct?
That's correct, Your Honor. There's only one allegation on that motion, and that's the charge you just pled to.
So let me go through the motion then. So in cause number 23-41505, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 27th of 2023, and that was a 10-year deferred probation. Is that correct?
yes,
It alleges that you violated your probation by failing to comply with the sex offender registration requirements that we just talked about. And is that true or not true?
Sure.
All right, and did you enter that plea of true to count one freely and voluntarily?
Yes.
And because it's actually true?
Good.
I also have documents here on the tablet in that case that you've signed with Mr. Parker. Did you also go over those with him?
Yes.
And do you understand them as well?
Yes.
State tenders number one,
Objection.
it's admitted. All right, Mr. Williams, I'm going to find in that case that you entered your plea of true to count one freely and voluntarily. Find count one true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. You have all the same conditions that you had, including getting that ID and getting all that taken care of. So you still now have an excellent opportunity. You're going to get out of custody. You're still on probation. You got a new probation, but I want you to understand if you don't follow through and get that ID taken care of and get registered the correct way, and you're back in here on another motion to revoke, I will have no choice but to probably send you to prison. You understand? So it's super important that you ask whatever questions you need of probation, ask Mr. Parker. They'll get you taken care of and help you, but ultimately you have to go get all that taken care of.
Yes.
Okay, I'm going to hand you, did the second one print?
First.
I'm going to hand you in each of your cases, the trial court certifications that shows that these were agreements that I followed. So you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. So you're going to get out today. Very important that the first thing you do is go talk to your probation officer. Okay, go straight there when you get out. Okay, good luck to you. You go back with a bailiff.
One thing,
Yeah,
I'm not gonna, try to do nothing to make it my matter worse and
good.
stuff, because I ain't gonna lie to you, I got 2 daughters.
Well, so it's time to take care of them, which means taking care of your business.
Yes.
So get out there, take care of your business, do everything you're supposed to, and you shouldn't have any other problems. But that's gonna be up to you.
Yeah.
Okay? All right, you go back with the bailiff.
Mr. Williams would be different.
Is he coming down? This is an agree that I think should be.
Yeah, that's child dental.
Mr. Cazada was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I received that pre-sentence report. Have you both had an opportunity to review the report?
You have your own. Yes, Judge.
In addition to that, I received an amendment or a memorandum from probation with regard to some information received from the complainant in the case, including a video that was sent to me. Did you all
I
get
got
that
it.
as well?
I got you.
Okay, so for the record, I've reviewed that as well. Any additions, corrections, or objections to the pre-sentence report?
No, you're not from the state. Excuse me.
So, Mr. Quezada, this gives me a whole lot of concern. I saw the video of what happened that night, and it was very scary what you did to her and what you put her through that night. And so I know there's reasons for this plea agreement, and I'm not saying I'm not going to go along with it, in my opinion, based on the fact that there's been a prior family assault. I'm not going to agree to a 5-year deferred. There's going to be more than 5 years involved in this. And I'm considering cognitive ISF as well. I mean, this was any input?
Your Honor, I would ask that he not be do ISF. He just recently got a job. He's supporting family, and I mean, they've been calling me just out of concern of that. he's their livelihood and I understand the court's concern. But I mean, I agree that we put him on, you can put him on more probation. That's, court can do that at their own discretion. And if there's any incident, then, which I don't think there will be, but
What's the current you're not married
No,
to her, are you?
no,
There's no relationship anymore, correct?
he's from the valley and that's, and he's living here now.
yeah, I have no communication with him.
Mr. Smith?
I don't believe there's any communication between the two at this point, Judge.
All right, so what I'm gonna do is I'm gonna find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney. But I'm going to defer all proceedings for 8 years instead of 5 years. I'm going to order the $500 fine. Obviously, all of the conditions of probation, including having absolutely no contact and no communication in any way with Veronica Panilla. I'm also going to order, at least for some amount of time, that you will be required to wear a GPS monitoring device. You'll have to have that on before you leave jail. They'll tell you how to get that taken care of. That at least gives me and everyone a little bit of, I don't know, comfort in knowing where you are at all times. If you're somewhere that you are not supposed to be, Mr. Smith will get me her information, where she works, where she lives, and all of that. The company will have that. Probation will have that information. If you get anywhere near that, there will be an immediate warrant for your arrest. You're going to be back in custody, and you're going to be looking at being found guilty and going to prison for up to 20 years. Do you understand how serious it is? If you do everything you're supposed to on this probation, this is a great opportunity. Because you don't have the conviction, you're gonna be able to keep your job, do everything, live right. Obviously, part of your probation is also going to be that you are not allowed to become intoxicated, alcohol or otherwise. I have a feeling that was involved, and so that is definitely something that is going to be very important. You cannot drink an ounce of alcohol, and you shouldn't have any issues. The other side to not doing everything right on your probation is, again, if you violate any condition at all, you'll be back in court, you'll be found guilty, which means you'll have the felony conviction, and you can go to prison anywhere in that range of punishment, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am. I got hired at the night shift, so I'll be.
So
shift.
you'll have a curfew, but just talk to probation about that as soon as you get out. Get them proof of where you work and what your shift hours are. I'm not going to prevent you from working if it's a night shift, but you have to make sure they have that information.
Thank you.
And if you're out during those curfew hours, it is only to go straight to work and straight back home. Okay?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back at the bailiff.
Thank you.
Mr. Lewis, you've got Jordan Thomas. Jordan Thomas. Good morning. Are you Jordan Thomas? And Mr. Thomas, in clause number 24, DCCR 0487, you're charged with the second-degree felony offense of sexual assault of a child from September 1st of 2023. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in clause number 24, DCCR 2178, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from August 18th of 2024. And that means the same thing. If you're found guilty in that case, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand that as
Yes.
well? In both of those cases, I have here on the tablet some plea bargain rejections that you've signed with Mr. Lewis. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in each of those cases that would run concurrently, which means together at the same time. You have every right to reject those offers and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plea. Do you understand all that?
Yes.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Thomas, Mr. Lewis has been appointed to represent you. Are you hired?
Hired.
Okay, perfect. Then Mr. Lewis will be in preparation for trial and we'll get you set on the next trial docket.
Yes, ma'am.
Thank you. Sorry, Mr. Lewis.
No problem. And Judge, I have Ms. Burge here to translate for me.
Perfect. On
Tellus.
Wanatellas. Thank you for letting me know that. Is there paperwork on that one?
No.
Okay, we're just go.
Yeah, we have an ice issue.
Okay.
He went in the back.
This year. Oh,
You can come off. Good morning, Ms. Burge.
Good morning,
If you
Judge.
please raise your right hand. Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you. Ma'am, are you Wanatellas?
Yes.
And this is 26 DCCR 1248. Ms. Tellez is charged with injury to a child from March 11th of 2026. And what is the announcement?
Judge, on this situation, we do have a immigration issue and also a concern of the children are staying with a not relative, but friend of my client. And of course, with the ICE issues, we don't know how exactly that's gonna play out. So we're trying to get a little more intel on that matter.
Okay. Any issue with the reset?
No.
So, Ms. Tellez, I'm going to reset your case to give Mr. Lewis some time to do a little more research with regard to the immigration issues. And then we'll see if we can get an announcement at the next court date. You can go back with the bailiff. Thank you, Ms. Burge.
Thank you, Judge.
Thanks.
Jean Thayer.
Hold on there for 1 second.
Sure.
Send a message to the probation front.
Yes, ma'am. Step today. You hear from Mr. Galmore on Kendrick Walker? Good morning.
Morning, Beth. How are you?
Good, how are you?
Walker. I'm doing great today.
Are you one that figured it out?
I don't think I was. She's like. I want to like. Hours for Lotso. Look at it. Good morning.
Good morning.
Don't know.
Right, sir, are you Kendrick Jamal Walker?
Yes, ma'am.
And this is 24 DCCR 0196. Mr. Walker is currently on probation for unlawful possession of a firearm by a felon and a motion to revoke that community supervision has been filed. It looks like he was placed on probation August 18th of 2025, and that was a 10-year term in prison that was probated for 5 years. The allegations looks like there's an allegation of a new offense of promotion of prostitution in Harris County from May 7th of 2026, failing to report by mail or online, failing to immediately report that arrest, failing to provide verification of performing community service, failing to submit to an alcohol or drug screening back in November of 2025, failed to remain in the state of Texas, and that he was in Arizona, traveling through Arizona and Las Vegas, and that he's behind his court assessed fees. Mr. Galmore has filed a motion asking that I set a bond. There's currently no bond. Is that correct in this case? Mr. Smith, what is the state's position with regard to bond?
The state's opposed to a bond in this case, Judge. It's a straight probation. It's not a deferred. He's not entitled to a bond. The fact that he's participating in promotion of prostitution through multiple states, not completely complying with the terms, not reporting the arrest, all show a lack of respect for the court and for the terms of probation.
I am taking judicial notice of the court's file. It does include in the administrative hearing that was received from probation, the offense information from the Houston Police Department. Give me just a second to just take a quick look at this. All right, you may go ahead.
Your Honor, can I go ahead and call Mr. Walker just for the limited purpose? of
Yes, sir.
addressing
Yes,
him?
ma'am. If you'll please raise your right hand the best you can, sir. Do you swear affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead, ma'am.
Go ahead and state your full name just one more time for me.
Kendrick Jamal Walker,
And Mr. Walker, where do you reside?
in Cypress, Texas.
Is that in Harris County?
Yes, ma'am.
Do you pay a mortgage there?
Yes, ma'am.
And who lives there at that residence with you?
Kennedy Wilson and, I have three kids.
What's their relation to you?
Uh,
Ms. Wilson.
my wife.
Okay. Do you have a vehicle?
Yes, ma'am.
Is that a reliable vehicle that would allow you to get to and from?
Yes, ma'am.
Do you have a bank account?
Yes, ma'am.
Approximately how much is in that bank account?
46,000.
46,000.
I believe.
Just correct, 4,600. All right. Do you currently have a job?
Yes, ma'am.
Are they aware of what's going on right now?
Yes, ma'am.
Did you notify them?
Yes, ma'am.
Do you still have that job currently if you were to be released on bond?
Yes, ma'am.
Where's that job located?
In Cypress, Texas.
Cypress, Texas, again, that's in Harris County.
Yes, ma'am.
Are you attending any colleges?
Yes, ma'am.
And where's that college located?
In Cypress.
Cypress, so again, Harris County.
Yes, ma'am. Long Star.
Do you have family here in the Beaumont area?
Yes, ma'am.
And you're able to frequently visit with them?
Yes, ma'am.
A strong support system with your family?
Yes, ma'am.
Just briefly, when you were arrested on the case before the court today, did you report that to your Harris County probation officer?
Yes, ma'am. You did.
Okay, and whenever she told you, or whenever you reported to her, what did she inform you?
That she advised me that Jefferson County would most likely put out a motion to revoke my probation.
And is that what happened?
Yes, ma'am.
And you knew that was happened when you reported at the next instance, correct?
Yes, ma'am.
So you had every intention of dealing with this head on,
Yes, ma'am.
no intention of running away from the situation?
No, ma'am.
Nothing further, Your Honor.
Any questions,
No
Mr. Smith?
questions.
All right, any other witnesses?
No, Your Honor.
I'm still going through a little bit. Give me just a second.
Yes, Judge.
So you say you're married to who?
Kennedy Woods, Walker.
Okay. But at the time of this new arrest, you said that you had this new girlfriend for 3 weeks.
This is a friend, and this is like not a girl, like a friend of just
Just a friend that's a girl.
this was an app that she told me.
Okay. Nothing. Like the underlying offense. Other than that possession of a controlled substance from 2019, Mr. Smith, is there anything else that you have?
From history and with MTLP funds, Judge.
Okay.
All I have is the PSI that. Underlying.
The indictment didn't allege anything else other than the possession from 2019. I was just trying to. All right, so what I'm going to do at this time, I am going to grant the motion. I'm going to set bond in Mr. Walker's case at $150,000. Condition of that bond, if it's made, is that Mr. Walker would be required to remain in Jefferson County, Texas without permission. I would need more information on job, location, things like that before I allowed him to leave. There would be a GPS monitoring device and all of the other standard conditions of probation, and then we will reset the case for an announcement.
Yes,
All right,
Judge.
can go back with the bailiff. Over.
May I be excused? Judge?
Yes, ma'am, thank you. Okay, that's okay. I wrote it on here, so I didn't forget. I did. Who? Okay. Mr. Lewis, Christopher Fair. That's his sentencing.
Judge, this one we have an agreement on. New pictures.
Okay.
Yes, we do that.
Good morning. Are you Christopher Fair?
Yes, sir.
And so this is cause number 18-30684. Mr. Fair was previously in court on a first amended motion to revoke unadjudicated probation and entered pleas of true to counts 1-6 and 9-12. There was no agreement at that time. I ordered an updated pre-sentence report. I've received that report. So let's start there. Have you both had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections to the report?
No.
Not from the state.
So it's my understanding, though, at this time, you guys have come up with an agreement on sentencing, however, instead of just leaving it up to the court. Is that correct?
That's
I don't need to go through any of the other allegations since he's pled to most of them.
No, Your Honor.
Okay. So Mr. Fair, I have now, in your case on the tablet, some documents that have your signature on them that the state's marked as exhibit number 1 that you signed with Mr. Lewis. Did you, go over those with him and do you fully understand them?
Yeah.
And I want to make sure you understand if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal.
Yes, sir.
State tenders number 1,
Yes, Your Honor.
no, Judge.
it's admitted. There's no evidence Mr. Fair's not competent. Well, Mr. Fair, you probably made a good deal today because I had some pretty bad notes on your PSI. I'm going to find that you previously entered your pleas of true to counts 1-6 and 9-12 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of indecency with a child. Sentence you in accordance with your agreement to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis.
Your Honor.
Yes, ma'am.
It's also to receive the sex offender registration now that there's an adjudication of guilt.
Probably should have been done at the original plea. Let me-
It may have, I wasn't here at that
Hold on, I
time. I
can
just
look.
want to make sure
Yes,
the record's
ma'am.
clear.
I do want to make you also understand that you will be required to register as a sex offender as part of, that was done back in 2019.
Okay,
He's been
good.
required to do that. Okay, all right, you can go back with the bailiff.
Thanks, Judge.
Nope, that's good. Judge Troya Green. Ms. Malfino, are you ready on the, Mr. Watts? Okay, I'll get to it in just a second.
Okay. One of those little jester hats.
You do need you're wearing lots of hats.
I have a short hearing on couch as well.
Okay. Good morning. Are you Judge Roya Green? And this is cause number 26 DCCR 1065. Ms. Green is charged with a first degree felony offense of aggravated assault with a motor vehicle, discharging a gun out of a motor vehicle. Is that correct? From May 16th of 2026. And what is the announcement?
Judge, I've gotten discovery and I've gotten an offer from Mr. Nichols. I have a counter offer that I've talked to Ms. Mofino shortly about this morning. I want to talk to Mr. Nichols about when he gets back. That's
Okay.
possible resolve this issue.
Okay, I'll just do one normal reset to give you time to get that taken care of. I'm sure Mr. Lewis will be out to see you as soon as he visits with Mr. Nichols, let you know all your options, and we'll get an announcement at the next court date. All right, you can go back with the bailiff.
It just changes it from straight to a cat to.
Okay. Okay, thank you, ma'am. Well. I think Mr. Lewis only has, what were we doing on Jean Thayer? You're ready on that? Let's do that one real quick, and that way Mr. Lewis is done. Jean Thayer, and then we'll take care of,
This is an old case, Judge, that has been told for several years by that motion. If it looks a little odd.
oh, okay, so the motion to revoke was filed back in
23.
23. And he's been at large. Good morning. Are you Jean Thayer Jr.?
Yes, ma'am.
This is clause number 18-28661. Mr. Thayer is on probation for the state jail felony offense of credit or debit card abuse. Looks like put on that probation back in May of 2019. It was a 3-year deferred probation. A motion to revoke that probation was filed in January of 2023 with the allegations that he failed to report to the Liberty County Probation Department in 2022, failed to report by mail to the Jefferson County Probation Department, behind in court assessed fees, did not provide documentation within 30 days regarding a budget sheet and things like that. The motion was filed, and then it looks like Mr. Thayer has been at large since then, and then arrested July of this year on the motion that's been pending since January 5th of 2023. Mr. Lewis has filed a motion asking that I set a bond in this case. Mr. Lewis, you may proceed.
Judge, this is a situation, like I said, it's definitely one that had been filed a long time ago. It looks like a situation where he had completed all of his conditions that he had, but he still had other obligations like the financial side and things of that nature. He was having some financial hardships. He has started working recently. Matter of fact, when he was arrested on this motion, he was driving his 18-wheeler and pulled over and was taken into custody on a job. So financially, he's back in a better position now where he can take care of those obligations, and including being able to
Well, let me
financially
stop you,
afford-
because part of the problem, I think, because of the age of it, it's over 5 years. He cannot be continued on probation ultimately in this case.
Oh, yeah, I understand. I
So
understand that.
it either has to be a revocation or a revocation with a straight probation, because the amount of time that's passed, am I correct, from 2019 to?
Well, and to go to that issue, Judge, what I've talked about with Ms. Morfino is that there are some issues that we definitely need to follow up on with the checking in, because according to my client, a lot of that was done. May have been, I think the mailing in problem is more the problem than the in-person for the longest time. And so because of that, I think if we can verify some of that, that'll be easier for us to make a decision if we're gonna be able to try to move this to a straight probation, or if there's something that he can actually move forward on. But my concern right now is him for his being in custody, see if we can get him out on bond. He's more than willing to comply with any GPS monitoring or anything like that what would require of him.
Where do you live, Mr. Thayer?
In Koontz,
Address?
12715, Highway 326 North, Koontz.
Ms. Malfino, what's the state's position?
Judge, I have spoken with Ms. Martinez, his officer this morning. With respect to some mitigating factors, I think that is what Mr. Lewis is leaning towards, that he may have been reporting elsewhere in person, but failing to do so by mail. So it looks more like his absconding than it actually was. I don't know that for sure. That's why at this time, based on it just looking like on paper, he's an absconder, I would object to a bond, Judge, because we finally now have him before you after this many years. The state can be prepared for a hearing on the motion. I mean, I can be prepared for hearing on motion 11 o'clock if you need me to be. But if we made a state jail offer in the alternative, I think the mitigation was what they wanted to provide for the court to lend towards that straight probation in lieu of the revocation.
I'm gonna do this. I'm gonna grant the motion to set a bond. It is a deferred probation. It's a state jail. I'm gonna set the bond in this case at $30,000. Condition of that bond is Mr. Thayer, that you are required to remain in either Hardin or Jefferson County. You must reside at the residence that you told me, 12715 Highway 326 North. You will be required to wear a GPS monitoring device. You will have to have that put on before you leave the Jefferson County Jail. As soon as you get out, if you make that bond, talk to Mr. Lewis, talk to your probation officer, and then we'll set your case for an announcement. All right, you can go back with the bailiff.
Thank you.
Thank you.
Oh, gosh.
Just like you don't.
All right, Marvin Watts. Marvin Watts. I want my voice back. I want my voice back. I promise I have not picked up smoking cigars. At least sound nice.
Snow.
That's
Ms. Japan, let's take on your client. You said he was for plea, and that's Mr. Moore.
Correct, Your Honor.
Will be on the record now in 2024, BU 2024, TR 1913. Please announce appearances.
Jared here on behalf of the state.
Anna Yumpen, and appears with Defendant Philip Moore.
What announcements, Ms. Japan?
Your Honor, we will be entering a plea of no contest to the second offense. In addition, there was another DUI that had been transferred over from El Dorado that the county attorneys has declined to prosecute. So we'll just be entering the plea on this today.
Very well. What is the plea agreement?
We'll just go ahead and be entering a plea to the standard minimums.
Okay, so plea discharged and then granted minimum recommendations.
Correct.
Mr. Moore, where are you?
I'm here.
Mr. Moore, I've heard what your attorney said. How do you plead to driving under the influence of alcohol or drugs after a prior conviction?
No contest.
By pleading no contest, do you mean you don't want to admit the charge, but you don't want to deny it and take it to trial either?
Yes.
You understand that means you're giving up your right to a trial. There will be no trial. You'll most likely be found guilty and unable to appeal your conviction.
Yes, ma'am.
Is anyone making you enter this no contest plea today by any kinds of threats or promises?
No.
Very well, Mr. Regier, is it Mr. Regier or Mr. Sweeney on this one?
I am present for purposes of this case, Your Honor.
Mr. Regier, is the state ready to prepare or provide a stipulation of what the facts would be or a proposal of what the facts would be to support this plea?
If the court is prepared to hear it, Your Honor.
I am, thank you.
Your Honor, pursuant to the affidavit, paragraph 4 appears to refer to a stop occurring on July 17th, 2024 at approximately 10:34 in the evening. It appears to refer to a specific location on West Central, just past Denver Street in El Dorado, Butler County, Kansas. Things are saying is that is well within Butler County limits, given this court jurisdiction. It would appear that the officer, where this case proceeded to trial, would testify that a white Chevy Tahoe was observed stopping in the right-hand lane. Further on in the affidavit, it would appear that the vehicle was observed hitting the curb for a second time. It would appear that pursuant to paragraph 7, the officer attempted to conduct standard field sobriety testing. However, it would appear that the defendant refused. Subsequently, after being taken into custody, the defendant was measured with a blood alcohol concentration of 0.173. That does appear to be well above the legal limit in this case, and the state's evidence would show the same. Additionally, the state would proffer, if the court is prepared to accept it, a journal entry of plea and sentencing in Butler County District Court case 2009 TR 4481. It would appear that pursuant to the same at a hearing on February 8th, 2010, the defendant pled guilty to 1 count of driving under the influence. The opening paragraph of the journal entry further indicates, quote, the defendant appears in person with appointed counsel Doyle E. White Jr.
The court finds the defendant has knowingly and voluntarily entered a no contest plea to driving under the influence of alcohol, a second conviction. The state has provided a factual basis to support that plea. The defendant is found guilty. Do we have an alcohol and drug evaluation for sentencing, Mr. Pond?
Your Honor, it was received. It was done back in March. I forwarded it over to the state previously.
Very well. Mr. Regier, can you send that to me without much delay?
One moment, Your Honor. Your Honor, I am not personally aware of any drug and alcohol evaluations. So would respectfully suggest if counsel for the defense can provide that to the state and to the court, this matter should be able to proceed fairly expeditiously.
Well, Ms. Japanin, we can either continue this to another day, although I think it was your intention to resolve it today, or we could put this further in the docket and let you resubmit that evaluation to prosecutor and to the court. What would be your preference?
Your Honor, I am going through my email. I am not seeing it here. I prefer to go to another day just so I know for sure that I have that.
All right. So, let's see. Jen, are you setting my sentencings on these?
Yes, I am. Are you wanting this on a control docket?
That'd be fine. Monday morning?
Yes. I have July 28th.
How about July 29th? Did that work for the parties?
No objection from the state, Your Honor.
That's fine.
Very well, Mr. Moore, I'm going to continue your bond with all existing conditions, plus the added condition that you and counsel reappear Monday, July 29th, 9 a.m. for sentencing. You must, before that date, sign any releases and get your alcohol and drug evaluation to your counsel, so she in turn can get it to Mr. Regier and to the court for that sentencing as it is required by law.
Yes, Your Honor.
All right, thank you.
Your Honor, just to clarify that Monday's the 28th, Tuesday's the 29th, which...
Okay, I wrote down the 29th, but I think Jen said the 28th.
Okay, all right, that's what I thought. I just wanted to confirm.
Okay, thank you for doing so.
And,
Mr. Moore, the 28th, Monday, July 28th.
Thank
and will
you.
that be by Zoom?
By Zoom, yes.
Perfect.
All right, thank
Thank
you.
you, ma'am.
Mr. Condon
Thank you.
and Mr. Moore are excused.
Thank you.
You're welcome. And Arnold was for dismissal, and Mr. Jensen, you're waiting to resolve your appearance today on Martinez, correct? And we were in recess on that. Mr. Regier, you were going to visit with some of your staff. Do you have any announcements back on the record in 24 CR 13, all parties as before?
Yes, Your Honor, if I may.
Please.
Your Honor, the state's understanding is that my office has been in contact with the victim as recently as within the last 2 weeks. So the state's understanding is that any lack of service of a subpoena insofar as the victim is concerned is a non-issue. However, the state is not prepared to proceed in this case absent the testimony of Officer Weekly. So for that particular reason, there does appear to be a witness issue and the state is requesting a continuance.
Do you know where your witness is, the officer? If I continue this, in other words, will you find him?
That would be the state's intention, Your Honor.
Well, I know it's your intention, but do you have any reason to believe you can find him? From what the response said on that subpoena, I'm questioning that.
Your Honor, based off my notes in the file, I believe the state will be in a position to proceed with the testimony of Officer Weekly if this court is prepared to grant a continuance in this matter. I would also note that this matter was previously set for pre-trial. However, it would appear that the court did revoke the defendant's court-appointed counsel upon statements of court-appointed counsel Darren Patterson at the time, and the matter was continued, and that and then the court had previously made findings that all prior continuances were assessed to the defendant for speedy trial purposes as of a misdemeanor control hearing on February 10th.
No, we've had 9 hearings in this case, the first one being January 8th of 2024, which is quite troubling. Attorney Jensen did appear with the defendant 210. That appears to be the first time after he took the case, after the defendant retained him. All right, so the state needs a continuance. Mr. Jensen, your response to that request for continuance?
We remain for trial today, Your Honor.
Well, I am going to reluctantly grant the continuance because the defendant has had so many continuances of his own. He had a misdemeanor control 1, 2, 3, 4, 5, 6, 7. 7 misdemeanor controls. And I realize you weren't counsel of record at the time, but I'm going to grant over objection the continuance. But I will note that it is over objection of defense. But I anticipate it will be the only continuance granted to the defendant, particularly on these reasons. At this time, we need to reset that, and my next jury trial date will be October 19th pretrial with 21st and 23rd trial. Isn't that correct, Jim?
October 19th is a Sunday.
The
All
next,
right.
the pre-trial is September 29th, with jury October 1st and 2nd.
Okay. September 29th, and your jury trial will be October
1st and 2nd.
Second. Okay, 1st and 2nd. I'll continue the bond, Mr. Martinez, but you are to continue with the existing conditions and reappear ready to go to pretrial September 29th. 9 a.m. we will begin. So be here by Zoom. Jury trial will be live in person beginning 9 a.m. October 1st and 2nd. Nothing further. Mr. Jensen and Mr. Martinez are excused.
Thank you, Your Honor.
You are welcome. Anyone else for plea? None of you could work out a disposition, or did you not consult?
Judge, I do have a number of cases ready for plea if you're ready to start taking those.
I am. In the meantime, I would urge breakout rooms for anybody that hasn't attempted to resolve your cases short of jury trial. James Watts, have you talked to the prosecutor about Neil Beeman?
I have not, Your Honor. I expect that one's going to proceed to trial.
Okay, is that tied to a felony, or is the felony resolved? Did someone tell me you resolved that?
The felony was dismissed some time ago, was transferred back to this court.
And Judge, if you recall, I have a Beeman case also. Mr. Watts has a Beeman case. Would it be all right to put the three, Mr. Regier and me and Mr. Watts in a breakout room real quick, talk about those?
Let's go ahead and do that. That's the only one on Mr. Watts' docket, on the docket with Mr. Watts. Jan, would you please put the prosecutor, Mr. Regier, and the defense counsel, Darren Patterson and James Watts, in a breakout room on Beeman? And Attorney Weishman's case on caps has already been reset, correct, Jen?
Yes.
Okay. And that brings us to, how about, and the Fleece case also, well, are they here, or did we go ahead and journalize that, Miss Norris?
That one's been journalized and has already been taken care of. Your Honor, you just mentioned PAPS.
I don't know that I did, but I certainly will.
Well, you just were talking about Mr. Weishman's case.
Oh, yes. I'm sorry. Yes.
Was that PAPS?
Caps with it. Yeah. Caps with a C.
Caps. Oh, I'm sorry. Cause I just wanted to clarify.
Well, I think we have a PAPS on here too. So that was.
We do.
And is that your case, Michael Paps? It's a Darren Patterson case, however.
No, Your Honor, it's actually Mr. Sweeney's / Mr. Regier's, but it's also Darren Patterson case. So
okay,
it's a possession of marijuana case. But yeah, I think without Darren, we can't proceed.
I think you're right. Do you have any, Miss Norris, that could proceed for plea or otherwise dismissal?
Your Honor, there are notes in several cases, but I don't think any of the ones left don't belong to either to Darren. I'm not sure if anybody else is represented by any other attorney.
Okay.
At this point.
I see what you're saying. Very well. So we'll just wait till Mr. Patterson comes back, because yes, it looks like they are all his from here out. All right, I'm going to close my screen and my microphone for just a moment till they come back. Mr. Patterson, are there any announcements on this matter?
Your Honor, after discussions, we have initiated plea negotiations. Mr. Regier has stated he would consider those, but is needing additional time. I'm not sure how much time he is needing for that, though.
Well, Mr. Regier, how much time do you need?
Your Honor, hopefully it would not be a particularly long endeavor, but again, I was not aware that any prospective plea negotiations could be made in this case until approximately 30 seconds ago. So I will need the opportunity to consider both these matters together before I am in a position to respond.
Can that be accomplished today, at some point in this docket if you're given enough time?
That would be the state's hope, Your Honor.
Very well. Do you need to take that time right now? And maybe I can use Mr. Patterson for some of these other defendants that are clients of his and another prosecutor?
Your Honor, if the court wishes to take both these matters up later on, perhaps towards the end of the docket, I don't think the state would have any objection.
All right. Do you need some time now, though?
If the court is prepared to grant it, I understand my colleague, Ms. Norris, and Mr. Sweeney will be called into other courtrooms momentarily before certain district court judges.
All right. Well, why don't you take what time available now, and I will see what I can accomplish with the other prosecutors before they have to leave to the district judges. How about the gentleman in jail? Mr. Patterson, are either of them ready to go?
Kyle Hughes, Your Honor, if we could do him, he's in custody.
All right, let's take up Mr. Hughes on the record in 2024 CR 513, State of Kansas versus Kyle David Hughes. Please announce appearances.
Amber Norris for the state.
Your Honor, Darren Patterson appearing on behalf of Kyle Hughes. Mr. Hughes does appear from the Butler County Jail. Judge, this is a case where my client is charged with theft and driving while suspended second. I have met with Mr. Hughes in jail. I've also reviewed basically everything going on with Mr. Hughes. He does have other Butler County cases that are set for jury trial pre-trials in July, as well as prelim in June. These are all felony cases. Judge, this is a case where I am asking the court to allow continuance of this jury trial to work on basically plea negotiations on the mixing it in with the felony cases, if that can be accomplished. Otherwise, this continuance would be at the speedy trial for purposes at the defense request, and would ask that it be set down for the October date for jury trial if we can't work anything out. But I think we probably could, Judge.
Do you know who the July jury trial is before, which judge?
I'll leave that to Ms. Norris. I don't have that right in front of me. I do have down that it's July 1 pre-trial, July 8 jury trial.
One moment, Your Honor.
Very well.
Judge, I believe that that's with Judge Hart. And Your Honor, we have been working towards resolving all of Mr. Hughes's cases. He's got, I think Mr. Patterson makes 3 attorneys and possibly, and I think at least 3 judges. So it's, we're still working on kind of coordinating the final plea, but I think that's going to happen.
What I'm wondering is if we could impose upon Judge Hart to maybe put this with the July jury trial.
Your Honor, the pretrial actually is on Tuesday, the 1st. I don't have any problem with that if Mr. Patterson doesn't.
I would think
the scheduled fine and court costs, as well as for the court to make a determination on the issue of attorney's fees if counsel for the defense is appointed in this case. For count 2, the circumvention of ignition airlock charge, the state would be recommending a $100 fine, subject to 120 days underlined sentence and a year of non-reporting probation.
Mr. Patterson, anything further?
Judge,
before
I am retained on this case, nothing further.
Mr. Lawless, at this time, on count one, your fine is $108. On count two, I'm sorry, strike that. Your fine on count one is $210. That's the scheduled fine. On count two, your fine is $100. You're also assessed $108 court costs. Your sentence will be 120 days suspended so long as you successfully complete a 1-year non-reporting probation. You don't have to see a probation officer, but you do have to follow the probation orders I'm about to give you. 1, you are to violate no laws of any kind during this 1 year. 2, you're to pay the total of $418. Can you, oh, wait a minute, maybe that's, no, that's right. Can you pay that within 60 days, or do you need a little more time?
60 days, ma'am.
And pay that within 60 days, don't violate any laws, and you will have satisfied this probation at the end of 1 year. If you
Yes,
want
ma'am.
to know how to pay that online or any other way to pay it, please call the clerk of the district court in Butler County at 316-322-4370. 4370.
Ma'am, the number broke up. I didn't get, all I got was 322.
All right. Call the Butler County Clerk of the District Court at 316-322-4370.
Last number.
0
70.
4370.
70. Okay. That's
Correct.
322-4370.
That is correct, yes. Anything
Hello?
else from anyone?
Not on this matter, Judge.
Okay, if there's nothing else, Mr. Lawless, you are excused from today's proceedings.
Thank you.
You are welcome.
Bye-bye.
Bye-bye. We'll now be on the record in 2024, BU 2024, CR 503, State of Kansas versus John Marshall Shoemaker. Judge Raquel for the state. Is John Marshall Shoemaker here?
Yes, I'm here.
The gentleman marked John McGee, Magee. You are also John Marshall Shoemaker.
Yes, ma'am.
The defendant appears in person and with counsel Darren Patterson. Mr. Patterson?
Judge, this is a case that will end up going to trial. I can tell the court that I had originally discussed with the county attorney's office that I would be requesting a continuance because I'm missing some witnesses. To explain that a little bit further, there are 2 eyewitnesses that were not subpoenaed by the state. I have now contacted and have clarification on one of them that they can be there on Wednesday and be prepared to testify. The other one, though, did have a child. The birth was last Thursday. And I'm a little bit tentative on knowing how to press somebody who's just given birth to be at court. So I have to continue with what I originally had requested, or that I told the prosecutor I'd request, which was a continuance to the next court date, so I can make sure and have both eyewitnesses, and these are actual eyewitnesses, Your Honor, present to testify.
All right, well, before I grant a continuance, this may be the case that needs to go. I'm gonna withhold ruling on the request for continuance and have Mr. Shoemaker McGay stay with us for a bit till we get to the end of the docket.
Yes, sir.
So we'll be in recess. We'll now be on the record in 2024 TR 234, State of Kansas versus Daniel Moriarty. Jared Regier for the state, Darren Patterson for the defendant, Daniel Moriarty, who also appears in person. If you'd start your audio and video, thank you, sir. Mr. Patterson.
Thank you, Judge. When announced this time pursuant to plea negotiation, the state has agreed to amend the charge to that of KSA 8235, no valid driver's license. To that amended charge, Mr. Moriarty will enter plea of guilty.
And do you so amend, Mr. Regier?
The state would so amend, Your Honor.
Very well, Mr. Moriarty, how do you plead to the amended charge of driving without a license in Butler County, Kansas on October 25th of 2023?
Guilty, Your Honor.
By pleading guilty, you're admitting that you drove without a license in Butler County on that day?
Yes, Your Honor.
And did you do that driving on Wednesday, October 25th of 23, as the officer alleges?
Yes, Your Honor.
And were you on Highway 54 at Southwest Santa Fe Loop Road, Augusta, Kansas, in Butler County?
That's correct, Your Honor.
And you didn't have a driver's license?
That's correct, Your Honor.
Anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, Your Honor.
You understand you're giving up your right to trial, including the jury trial we're set for, and that you'll be found guilty and unable to appeal your conviction?
I do, Your Honor.
All right, I accept your plea as freely and knowingly given, and a factual basis exists to support it. Finding the defendant guilty, I would inquire of sentencing recommendations, Mr. Regier.
Yes, Your Honor. Pursuant to plea negotiations, the state is recommending a $100 fine, that the court make a determination on the appropriate amount of court costs, as well as a $60 probation fee. The state is further recommending that the court make an appropriate determination on the issue of attorney's fees, as well as impose a 12-month reporting probationary period subject to a 6-month underlying sentence, the maximum sentence allowed by law for a Class B misdemeanor.
Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Moriarty, where do you work?
I work at DHL Logistics for Case New Holland.
Okay. At this time, I am ordering you to pay a fine of $100, also assessing $250.
And Judge, I'm sorry, I'm retained in this case.
Oh, you're retained. Okay. You did say that. I am ordering a fine of $100 and assessing 108 court costs and $60 probation supervision fee. Your sentence will be for 6 months. That will be suspended so long as you comply with your 12-month non-reporting probation. You have but two conditions of probation. One, violate no laws during this 12 months and pay the total of $268. Can you do that within 30 days, sir?
I will have you guys paid on Friday.
And Your Honor,
Mr. Regier?
Forgive my interjection. If the court is assessing a $6 probation fee, is that a 12-month reporting probation? That was the state's understanding of the plea deal negotiated in this matter.
You're recommending reporting probation, Mr. Regier?
That was contemplated by the plea agreement reached between the state and the defense, as I understand it, Your Honor.
All right, well, I will follow the plea agreement, so you will have to report as directed. Contact probation at 316-322-4153. Call them as soon as this hearing is over. And if you don't get them, leave a number and call after lunch. But again, it is $100 fines, 100 court costs, $60 supervision fee. It is a 6-month sentence. It is still suspended, but you will have to report to probation as directed. Anything further?
Judge, only additional item is that talking with Mr. Moriarty this morning, he was concerned about making sure probation knew that he had a pre-planned trip already to Texas in July, I believe it was. I told him as long as he speaks with his probation officer about that, there shouldn't be a problem with that. I just wanted to bring it up since Mr. Moriarty was concerned about it.
The court is granting you permission, Mr. Moriarty, to take that trip, but you do need to get it approved by court services before
Certainly,
you
Your
go.
Honor.
All right.
Certainly.
All right, nothing further. You are excused at this time, sir.
Thank you, Your Honor.
You're welcome. We'll now be on the record in PAPS, that is BU 2024 CR 431, State of Kansas versus Michael Lynn Papps, Jared Regier for the state, Darren Patterson for the defendant. Michael Papps, who also appears in person. Mr. Papps, start your audio and video, please. Thank you, Mr. Papps. Mr. Regier, I'm sorry, Mr. Patterson.
Your Honor, pursuant to negotiations, I would announce this time, Mr. Papps will be entering a plea of no contest to count 1, possession of marijuana. States agreed to dismiss count 2, possession of drug paraphernalia.
That is your agreement, Mr. Regier?
That is the state's understanding, Your Honor.
How do you plead, Mr. Papps, to count 1, possession of marijuana?
No contest.
By pleading no contest, you're not admitting the charge, but you don't want to deny it and take it to trial either?
Correct.
Anyone making you enter this plea today by any threats or promises other than the plea agreement?
No, ma'am.
And you understand with this plea, you're giving up your right to trial and will be found guilty and cannot appeal your conviction.
Yes, ma'am.
Very well, Mr. Regier, factual basis.
Yes, Your Honor. Pursuant to the amended affidavit in this case, paragraph 4 appears to refer to an encounter occurring on May 1st, 2024 in the 19,000 block of Southwest Butler Road, Butler County, Kansas, involving a 2008 Toyota Camry. It would appear that a traffic stop was conducted by law enforcement the defendant was located as an individual occupying the vehicle. Subsequently, pursuant to paragraph 12, it would appear that law enforcement conducted a search of the defendant, and inside the defendant's right front pocket, law enforcement discovered a vape cartridge containing a fluid consistent with THC juice, which was later subject to field testing. That's quoting directly from paragraph 12 of the affidavit.
And field testing confirmed the presence of marijuana.
Your Honor, were this case to proceed to trial, the state's evidence would show the same.
Very well, count 2 is dismissed. The defendant is found guilty of count 1, possession of marijuana. Mr. Regier, recommendations for sentencing.
Yes, Your Honor. At this time, the state is not recommending a fine. However, the state is recommending the imposition of court costs and a probation fee, and for the court to determine attorney fees. The state is further recommending on the sole count remaining before the court an underlying sentence of 120 days, subject to a 6 months reporting probation, and that the defendant be ordered to complete a drug and alcohol evaluation and follow all recommendations. I further do not know whether or not this final issue was discussed during the context of plea negotiations. However, this does appear to be a case where KBI restitution applies.
Anything further, Mr. Patterson?
Judge, I am court appointed in this case. I would tell the court I am aware of the KBI report that the drugs were further tested and acknowledge that there is a fee for that. Nothing further.
Thank you. Mr. Paps, where do you work?
I'm currently unemployed.
When did you last work?
It was about 2 months ago.
And what did you do at that time? What kind of work?
I was working for a construction company called Savvy Builders.
And why do you no longer have that employment?
Due to attendance.
Attendance?
Yes,
Are
ma'am.
you looking for work? Are you planning to have work in the near future?
I just need to get transportation and I can get that job back.
And who's supporting you these past 2 months?
My wife.
At this time, you are ordered to pay the KBI $400. There will be no fine. There will be $158 court costs. There will be $60 probation supervision, and I am imposing $250 attorney fees because I believe you can work. You just need to do so. I will grant you a 6-month controlling sentence that will be suspended, provided you I'm sorry, I strike that. I am giving you a 120-day jail sentence that will be suspended, provided you successfully complete reporting probation. Mr. Regier, was the plea agreement that be for 6 months?
That is the state's understanding, Your Honor.
Ma'am,
Yes.
sorry. I just wanted to let it be known that I currently live in Wichita. That transportation would be really hard for me to get back and forth.
Well, the alternative is to have you serve the 120 days in jail. You want to do that?
I mean, I'd rather not. I'll try my hardest to get there. I mean, I'll have to reach out to some, like my mom and whatnot, but.
Well, how do you get to work? Oh, you said you're going to get someone to take you?
Right.
I'm going to make this a 12-month reporting probation because I just don't foresee you getting everything done in 6 months. I am ordering that you find employment and maintain it. I am ordering all other standard conditions. You are ordered to get a drug and alcohol evaluation and comply with it. You are to call and schedule that evaluation within the next 14 days. You are to pay a 12th of the amount owed, which includes $400 KBI, 158 $158 court fees, $60 probation supervision fee, and $250 attorney fees. Pay the rate of 1/12 per month, 1/12 due on the 19th of each month. First payment due June 19th, 2023. Call the probation office immediately after court. Are you ready to write it down?
Yeah. Go ahead.
I'm just curious, did you hear me tell everyone to get a pencil and paper a while ago?
My wife has her phone. She has it right now.
So you did hear me?
Yes, ma'am.
All right. Call the probation department at 316-320-4153.
Yes, ma'am.
Call them immediately after court. If they don't take your call the first time, leave a message Call them later in the day to make sure you get through. Make sure
Okay.
also that you have that appointment for alcohol and drugs scheduled within the next 14 days. Make sure you follow all of its conditions. Sign any releases necessary for the evaluator and treatment provider to correspond with your probation officer.
Okay.
Mr. Aguirre, anything further?
Not on this matter, Judge.
Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Paps, anything further?
No, ma'am.
Thank you. Then you are excused at this time, Mr. Paps. You may go. We will now be on the record in 2024 CR 388, State of Kansas versus Justin Lee Thorburn. County Attorney Jared Regier for the state, Attorney Darren Patterson for the defendant, Justin Lee Thorburn, who appears in person. Mr. Patterson.
Your Honor, after further discussions with Mr. Sweeney, there was a agreement that this case would be dismissed with prejudice because it was part of a previous global plea bargain on some felony cases that my client's currently on probation for.
And as a representative of the state, you support that and so move, Mr. Patterson? Or Mr. Regier?
One moment, Your Honor. I am in the process of confirming that, if the court will allow it.
Certainly. Go ahead, please.
Your Honor, based off of my notes, that would appear accurate. Unfortunately, I'm not in a position to advise the court as to which specific cases.
Very well. Mr. Thorburn, at this time, you are excused. The parties will journalize, if they have not already done so, your dismissal with prejudice. Thank you.
Thank you.
You're welcome. We will now be on the record in Tullis, BU 2023 TR 3074, State of Kansas versus Lucas Tullis. Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Patterson, announcements?
Thank you, Judge. I would announce this time Mr. Tullis is going to enter plea of guilty to the charge of driving after being declared a habitual violator.
Mr. Tullis, how do you plead to count one, driving after being declared an habitual violator? How do you plead? I'm sorry, sir, I didn't hear you. We're having a hard time. You're not putting out any sound.
He spoke to me earlier, Judge, so not for sure what's happened. There, say it again, Mr. Tullis, say this.
Hey, can you hear me now?
Yes.
I plead guilty.
By pleading guilty, you're admitting that you did drive in Butler County, Kansas on July 30th of 2023 at a time while your driver's license was revoked due to habitual violator status?
Yes, ma'am.
And are you pleading guilty because you believe you were in fact guilty?
I am guilty, yeah.
And you understand you're giving up your right to trial, including the jury trial we have reserved for you with this plea?
Yes, ma'am, I do.
And do you understand that you'll be found guilty and won't be able to appeal that conviction?
Yes, I do.
And is anybody making you do this today?
No, Your Honor.
Did this happen as the officer's affidavit alleges out on Highway 54 outside of Augusta, approximately 7:40 a.m.?
Yeah, that is correct.
All right, I find that your plea is freely and knowingly given with a factual basis. Oh, and your license had been declared habitual, you said, right?
Yes, ma'am.
Prior thereto. All right, I find you guilty. Recommendations for sentencing, Mr. Regier.
Yes, Your Honor. The state's understanding is this is a case where the elevated sentence under KSA 287 applies. Therefore, pursuant to plea negotiations, the state is recommending the minimum fine required by law of $1,500. Also, pursuant to plea negotiations, the state is recommending court costs and a probation fee of $60 and for the court to make a determination on the issue of attorney's fees. The state is further recommending an underlying sentence of 1 year, subject to 1 year reporting probation. The state is not opposed to any orders the court may make as far as courtesy supervision is concerned, also pursuant to plea negotiations. The state's understanding is that pursuant to KSA 287, quote, the person convicted shall not be eligible for release on probation, suspension, or reduction of sentence or parole until the defendant has served at least 90 days imprisonment. The 90 days imprisonment mandated by the section may be served in a work release program only after such person has served 48 consecutive hours imprisonment, provided such work release program requires such person to return to the confinement at the end of the work release program. The state is prepared to recommend that the court follow the statute insofar as 48 consecutive hours and any other orders the court may deem appropriate insofar as the 90 days are concerned.
Well, we don't have a work release program here, do we?
Judge, the statute also allows house arrest program, and that is part of the agreement.
Does it actually allow it, or it's just silent on house arrest?
Your Honor, pursuant to at the very conclusion of KSA 8287, it does appear to provide, quote, the court may place the person convicted under a house arrest program pursuant to KSA 216609 and amendments thereto, or any municipal ordinance to serve the remainder of the minimum sentence only after such person has served 48 consecutive hours imprisonment.
Okay. All right, at this time, Mr. Tullis, you live in what area, what town, city, state?
North of Emporia, Lyon County.
Lyon County, okay. Where do you work?
Simmons Pet Food.
And Your Honor, if the court wanted further information, I did send an email to court and counsel this morning with some additional documents. Those documents included a letter from his community corrections officer that outlines the things that he's currently involved in, which includes drug court, which includes that he is a part of the Corner House alumni group where he has already completed his drug and alcohol treatment completely. He is employed. My client also provided the drug court meeting criteria they go through, as well as some of his other meetings he has, and the breakdown of his monthly costs, which includes Butler and Associates taking $1,100 out of his paychecks, which is why he basically works a second job because of how much he's paying there. But those are additional documents for disposition in the case, Judge.
Very well. At this time, Mr. Tullis, you are fined $1,500 and ordered to serve a 1-year sentence. You also have attorney fees of $250, court costs of $108, and supervision fees of $60 because I am granting you a 1-year reporting probation after you've served 90 days. I don't want you to lose the job you have, so I will let you serve that 48 hours in jail, followed immediately by the remainder in house arrest, and only allowed to leave the house for work release. and to go directly to work and directly home. You're allowed to have courtesy supervision in your home county if that can be arranged. You are to pay 1/12 of the total due each month on the 19th day of each month. Your first 1/12 payment is due on June 19th of 2025. You are to start serving the 90 days within 1 week. When do you want to check in?
So it was my understanding that I was going to need to be put on house arrest before going into jail, or is that something that I can do upon immediate release if I had that set up?
What I'm envisioning is you serve the 48 hours, but before you go in, you contact the ankle monitor, electronic monitoring people so that they will show up when you get out of jail.
Okay.
And you'll go immediately onto that and immediately home.
Okay. Can we do that Monday? I guess that's Memorial Day.
And he's thinking of his days off from work, Your Honor. He's not a weekend person. He's a weekday is his off days. That's why he's asking for Monday.
You can begin that Monday, I believe that's the 26th. At what time are you checking in? 7 a.m.?
I'll be there. Yeah, 10 a.m. works great.
10 a.m. You must be there with the photo ID out there at 701 Stone Road. And like I said, call your EMD, electronic monitoring, and have them ready to show up when you get out.
I can do that. My only question is, so I am on felony corrections here in Lyon County, part of a drug court program. And I do have to go to court once a month. I have to go to an alumni group for drug and alcohol treatment once a month. And I have to attend 3 meetings a week. That's NA, church, AA.
I will authorize court appointments and treatment appointments.
Okay. Yeah, I just wanted to specify that. Okay.
Thank you for inquiring. Anything else?
I need to call probation right away, or?
Yes, call them right after court at 316 322 4153.
4153.
And Mr. Patterson, do you have the EMD number for him?
Yes. Write down this phone number also and call them after probation. 316 322 0021.
0021.
Correct.
Okay, I will call both of them right now.
All right, Mr. Patterson, anything further?
Nothing further.
Mr. Regier,
One moment, Your Honor.
while you're taking a moment, Deputy.
Judge, what was the charge on that?
His charge was driving after being declared habitual violator.
Okay, sounds good. Thank you.
Thank you.
Nothing further from the state, Your Honor.
All right, then we are in recess. Mr. Tullis is excused to call probation.
Thank you so much.
You're welcome. We'll now be on the record in Warren, case number BU 2024 TR 1832, State of Kansas versus Joel Patrick Warren II. Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Patterson.
Judge, pursuant to plea negotiations, I would announce at this time, Mr. Warren will be entering a plea of guilty to count 3, no proof of insurance. States agreed to dismiss 1 and 2.
Mr. Regier, that's your agreement?
That is the state's understanding, Your Honor.
Mr. Warren, that's your agreement?
Yes, ma'am.
How do you plead then to count 3, driving in Butler County, Kansas on July 8th of 2024 without liability insurance or proof of liability insurance?
Guilty.
Guilty, you're admitting that you did drive without insurance?
Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
You understand that you will be found guilty, having given up your right to trial, and you'll not be able to appeal your conviction with this plea.
Yes, ma'am.
And where were you driving in Butler County without insurance when the officer stopped you?
On the turnpike?
I-35, Kansas Turnpike.
Yes, ma'am.
And if the officer said you were doing so at mile marker 57 north in Butler County, you'd agree with that?
Yes, ma'am.
All right, I will accept your plea as knowingly and voluntarily made, find you guilty. Recommendations, counsel?
Yes, Your Honor. Pursuant to plea negotiations, the state is recommending the minimum fine required by law of $300, as well as the imposition of court costs. State is further recommending a 6-month non-reporting probationary period subject to an underlying sentence of 120 days.
Mr. Patterson?
I am retained in this case, Your Honor, nothing further.
Okay. Mr. Warren, where do you work?
Dillon's in El Dorado.
Full time?
It's part-time right now, but I'm gonna be looking for some full-time employment.
And Judge, I'm retained in this case.
Oh, I thank you. All right, at this time, you are fined $300 and assessed court costs of $108. You're given a sentence of 120 days, but that is suspended so long as you successfully complete 6 months non-reporting probation. The non-reporting probation has 2 conditions. 1, do not violate any laws during the next 6 months. 2, pay the 408. Can you do that within 30 days?
Can I have 60 days?
You can have 60 days.
Okay.
Is that going to be enough?
Yes.
All right, I'm going to order that you pay the 408 within 60 days. As long as you pay within 60 and violate no laws, you'll be in compliance with your probation. Anything further, Mr. Regier?
Not on this matter, Judge.
Mr. Patterson?
Nothing further.
Then we all are in recess and Mr. Warren is excused. Oh, and for the record, the other counts are dismissed on motion of the state.
Thank you.
Thank you. You may go, sir.
Thanks.
You're welcome. We'll now be on the record in 3 cases. BU 2024 CR 288, BU 2024 CR 291, BU 2024 CR 374, each captioned either State of Kansas versus James R. Young or State of Kansas versus James Richard Young. Jared Regier for the state, Darren Patterson for the defendant, who appears in person on all 3 counts or cases. Mr. Regier or Mr. Patterson?
Your Honor, these are announced for trial.
These are for trial. Can we consolidate these? Any reason we can't?
I apologize. I didn't understand the court.
Any reason why we couldn't consolidate these?
I would object to consolidation. Yes, Judge. I think the facts are pretty different from one another, as well as there's one that they have different victims, so that there's no motion on file to consolidate.
All right. Well, court on its own motion brought it up. Okay. Count in 24 CR 288. The defendant is alleged of violating a protection order. And that was alleged on June 16th of 24 with the no contact meeting with Elizabeth Goucher. Then in the 291, Violation of a protection order, May 10th, the previous month, May 10th of 24. Does not say who the contact was with. Is it alleged to be Elizabeth Goucher also?
Yes, Judge.
'24 CR 374, domestic battery. And that allegedly occurred August 2nd of 24. After the two violations. With Tricia Williams. All right, I see where the Tricia Williams would be different. How about the two cases with the same victims, the two protective orders?
Judge, I am not prepared to take that up. It's not before me. I haven't received a motion for it. I haven't researched it. Right now, they're two separate cases, so I guess I object to it coming up right now.
All right, which of those three do you prefer to take up? They all happen within a couple months of each other.
James Young's phone died. He's running into the courthouse right now. James Young.
Okay, James Young's phone died. He's running into the courthouse right now. All right, we'll give him a minute.
I was right in the middle of my Zoom report, so I need to go down to the tab. My phone overheated.
And Judge, my client's relocating to the courthouse. She's having phone issues.
Noted.
Okay, Judge.
All right,
Sorry, Your Honor, my phone overheated right at that moment.
well, I'm just glad you're at the courthouse so we could proceed. We are continuing with the three cases concerning James Young. So the defense counsel has made it abundantly clear that they object to consolidation as the court had considered. The cases will not at this time be consolidated. So Mr. Patterson, do you have a preference that you want to see them tried in, since they all allegedly happened within a few months of each other?
Judge, I would leave that to the state on which one they want to present.
Very well. Mr. Regier, does the state have a preference?
Your Honor, no preference per se. What I would tell the court is I have not had the opportunity to speak to counsel for the defense regarding this case, so I'm not sure if the defense is even if the defense is even prepared to enter into plea negotiations. I just want to make that clear for purposes of the record. I'll of course defer to counsel for the defense.
This courtroom hearing takes a serious turn when Bradley Shire appears before the judge for a misdemeanor battery case while already facing a separate probation revocation matter. The court explains that Shire has agreed to plead guilty to the battery charge, with the other charges being dismissed and read in. But before accepting the plea, the judge carefully goes through his constitutional rights and makes sure he understands exactly what he is giving up by choosing a guilty plea. Shire confirms that his attorney reviewed the paperwork, the evidence, the possible penalties, and his right to a jury trial. Everything seems ready to move forward. until one question suddenly changes the entire tone of the hearing. When the judge asks whether the facts in the criminal complaint are accurate, Shire initially says he does not agree with them. His attorney immediately explains that if his client is disputing the facts, the case would need to go to trial. The judge makes it clear that she will not accept a guilty plea from someone who refuses to take responsibility. She tells Shire that if he is not guilty, he has every right to have a jury hear the case and require the state to prove guilt beyond a reasonable doubt. But if he wants to plead guilty, he must be honest about what happened. After being questioned directly, Shire finally admits that he put his hands on the victim, that he did not have consent, and that his actions caused her harm. The judge repeatedly confirms each part of his admission before accepting the plea. What makes this moment even more important is what happens during sentencing. The prosecutor argues that probation is inappropriate because Shire committed the battery only 3 days after being placed on probation for another felony. The state also points to his lengthy criminal history, previous alcohol-related offenses, domestic and battery-related convictions, and repeated periods of probation and incarceration. The prosecutor asks the court for 6 to 9 months in jail, arguing that punishment is necessary not only for specific